How do you pass real estate down to your kids when you don't have a will? When you don't have a will, your assets get split per the intestate laws of your state. As an example, in Georgia, your assets get split evenly between your spouse and your kids, with your spouse getting a minimum of 1/3. And so if you don't have a surviving spouse, the kids will split everything equally. And so if you're trying to pass real estate down to your spouse or your kids, you have two options here. One, you can sell that property and distribute the money out to your family, or you could keep the property and distribute the ownership out to the family. And so in that case, everyone would co-own that property together, which will naturally create conflict because someone's going to be like, I want to live in it. I want to sell it. I want to rent it. I don't want to touch it. I don't want to put any money in it. I'm going to have to touch it and I'm going to have to put money in it. So there's naturally conflict related to co-owning that property when you pass it down to them. And so those are the two options that you really have. There's a lot of nuanced details there that you have to figure out when you're trying to distribute the property down to your kids. If you want to avoid the probate process, you have a couple different options. You could do a joint tenancy rights to survivorship for your spouse. You could do a transfer on death deed for your kids, or you could do a revocable trust, and that gives you flexible options on how to distribute that property out to your family. If you want help with any of this, click link in the bio, fill out the form, and schedule a time to talk to some of our team.